All right, let's talk about a really fascinating constitutional puzzle that's playing out in India right now. It's a story all about the friction between elected state governments and the governors who are appointed to oversee them.
So just imagine this for a second. Your state's elected leaders, they debate a new law, they pass it, and it goes to the governor for the final signature to become official. And then, crickets. Nothing. Weeks go by, maybe even months. What happens then? Well, this isn't just some textbook hypothetical, it's a very real problem, and it's at the core of what we're digging into today.
And you know, this isn't just happening in one place. This constitutional showdown is really flaring up in a few opposition-ruled states. Think Tamil Nadu, Kerala, and Punjab. The state governments are basically saying that the governors, who are appointed by the union government, are stalling on purpose, just indefinitely sitting on bills and bringing the whole legislative process to a grinding halt.
So how serious is this? Well, this number really says it all. 10. That's the number of bills the governor of Tamil Nadu was accused of holding up. 10 different laws, all passed by an elected assembly, just stuck in limbo. And that level of delay is exactly what pushed the state to do something pretty drastic. Take the whole issue to the Supreme Court.
So, what is this power that governors are being accused of using? Well, there's a term for it, a colloquial one, but it's pretty powerful. It's called the pocket veto.
The name pocket veto really paints a picture, doesn't it? The governor doesn't officially say no to the bill, they just do nothing. They effectively stick it in their pocket, and the bill is just left hanging in this state of suspended animation. The government can't move forward with it, and there's nothing the legislature can do.
Now what's fascinating is that the Constitution itself, in Article 200, is actually super clear about what a governor is supposed to do. They get a bill and they have three options. 1, they can grant assent, sign it and it becomes law. 2, they can withhold assent, basically send it back with notes. Or 3, they can reserve the bill for the president to look at. Notice what's not on that list? Just waiting forever.
And this brings us to the key phrase in the Constitution. The governor has to act as soon as possible. The Supreme Court really honed in on this. They said, look, the people who wrote the Constitution meant for there to be a sense of urgency, and they put it so perfectly. The phrase is, as soon as possible, not as late as feasible.
So, with all these bills piling up, the Tamil Nadu government finally took their case to the Supreme Court. They were looking for a final, definitive answer on this, and the court's judgment was a really big deal. It basically set new, clear rules for what a governor can and cannot do.
So the court's ruling really created some new guardrails. Let's break down the key points. First, they said there is no such thing as an absolute pocket veto. Done. Second, governors have to act in a reasonable time, and the court suggested that's something like 3 months. And here's where the ruling gets its real teeth. If a governor wants to delay longer, they have to give a good reason. And maybe most importantly, their decision to withhold assent can be challenged in court. It pulls the whole process out of the shadows.
So, with a ruling that clear, you would think, okay, that's it. Problem solved. The rules of the game are clear now. But this is where our story takes a really unexpected twist. Just about a month after that big decision, the union government, through the president, had a question for the very same court.
And this next move came through a very rare constitutional tool, something called a presidential reference. This is a mechanism that lets the executive branch, the government, ask the judicial branch, the Supreme Court, for its opinion on a matter of public importance.
So, Article 143 is kind of like a special hotline between the president and the Supreme Court. The president, on the advice of the government, can send a question over to the court and ask for its advisory opinion. It's a way to get legal clarity without going through a whole new lawsuit.
And here is the absolute heart of this new standoff. It's almost a bit of a head-scratcher. On the one hand, you have the Supreme Court's ruling, which just said, yes, the court can read a time limit into the governor's duties. But on the other hand, the new presidential reference asks, hey, can the court actually prescribe a time limit for the governor? The executive is essentially asking the Supreme Court to go back and check its own work on a decision it literally just made.
And this wasn't just a single question. No, the reference had 14 different questions for the court. And legal experts who looked at them pretty quickly pointed out that, hang on, the vast majority of these, we're talking 10 to 12 of them, seem to be about issues the Supreme Court just settled in the Tamil Nadu case.
Now, the Supreme Court doesn't actually have to answer these questions. And if you look at history, they've kind of gone two ways on this. In the Kaveri water dispute, they took a very conservative stance, basically saying, we're not going to answer questions we've already ruled on.
But in the 2G spectrum case, their view is a little more expansive. They agreed to clarify some things for the future, but they made it clear they weren't going to overturn their original judgment.
So look, this is way more than just a dry legal argument for constitutional nerds. This whole standoff has huge implications for India's federal structure, the balance of power between the central government and the states, and really the basic functioning of our democracy.
Let's just spell out what's really at risk here. First and foremost, you're talking about undermining the democratic will of the people in a state. You're letting an appointed official effectively choke off laws passed by elected leaders. But then it gets even bigger. You're challenging the final authority of a Supreme Court judgment, which some experts warn could create inroads into the independence of the judiciary. At the end of the day, it could leave states with no real legal way to fight back against a governor who just won't act.
And that brings us to the big, lingering question here. The Supreme Court stepped in to provide some much-needed clarity, to resolve a deadlock. But by asking the court to essentially rethink its own fresh ruling, has the executive just risked opening a massive constitutional can of worms, maybe creating even more confusion? It's a question with no easy answer, and it leaves the whole country's delicate balance of power just hanging in the balance.